Good evening, everybody. You're all very welcome. It's my great pleasure to welcome you to this evening's event and another in this series of talks that we have done on Article 41.2 of the Constitution. By way of background, just in late 2018, the Irish Women's Lawyers Association commissioned research into Article 41.2, mindful of the forthcoming referendum that was proposed at that stage, but has since been delayed. And we've hosted a number of podcasts and webinars, which are available on our website if the topic is of interest to you beyond this evening's talk. And our aim basically throughout this process has been to educate and inform our members so that we can all participate in whatever debate takes place. The format this evening will be a presentation followed by a question and answer session. We hope you'll get involved, ask questions, express your view, and that it's a lively and engaging evening. And that's certainly been our experience of events to date. This evening, it's my very great pleasure to say that we're joined by Dr. Laura Kahalan. Laura is a senior lecturer in the University of, in School of Law at the University of Limerick. She has a long and very impressive CV, so I have literally picked a few highlights from it. She completed a first-class honours Bachelor in Civil Law with Law and French at UCC, and she then went on to complete her Master's and her PhD. Her PhD topic was the drafting of the 1922 Constitution. Her research interests include constitutional law and legal history, and she's published nationally and internationally. I think she's probably the leading expert in the country on Article 41.2, and I think I can say that on the basis that, among other things, she has just last month presented to the Citizens' Assembly on the topic. It's my very great pleasure to introduce her and to ask her to give her presentation this evening. Thank you, Laura.
Thanks very much, Anne, and thank you for the invitation to speak this evening. As I was saying on Twitter today, I think it's so important that we do have a discussion on this issue at the moment. And as you all know, there was a proposed referendum a couple of years ago on this, and it didn't go ahead because there was a feeling that there hadn't been a sufficient conversation on what exactly we wanted to do in terms of reform. So it's really important that we do have that discussion now, particularly when it is currently under consideration by the Citizens' Assembly at the moment. And with that in mind, I would like to talk to you about the article itself tonight, and I'm going to share my screen there. I'll try not to speak for too long about this. The danger is when I get started on this, it's pretty hard to stop. So I presume that is a sharing for you there now. I just want to talk to you about the origins of the article itself, so the influences behind it, the fact that it actually did have potential as a rights-giving article for women, but that potential was never actually borne out. So either by political decisions along the line or the case law, and there really wasn't much case law on it. And because that it never really went in that direction, it now has become this embarrassing anachronism in our constitution. And we'll look at options for the future at the end, but maybe first we'll just have a look at the article itself. Now, every year when I'm teaching constitutional law in UL, the first thing I do is ask my students to have a look through the Constitution and just see what jumps out at them, to pick a provision. Is there something that interests them or intrigues them? And we have a discussion about it. And every year, this article, without a doubt, is the one that inspires most discussion amongst the students. And the ones who've never seen it before are looking at it going, what on earth is this? And the ones who have seen it are going, why is this still in our Constitution? And what is it doing there in the first place? Why was it put in there? So I might start with that question on the origins and the intent of the provision itself. Now, many writers have mused about the potential original intent of this particular provision and the reasons for putting it in the Constitution in the first place. And it's worth noting that it wasn't in the 1922 Constitution. There was nothing like it. So it was an innovation in 1936. And it was one of the first new editions that we see in 1936. And the first trace of it appears in the early drafts in the form of protection of maternity. And this sentence appears in John Hearne's draft heads in October 1936. Now, John Hearne is the principal drafter of the 1937 Constitution. So when he's drawing up his first ideas, this is what he has on family, and it's this idea of protection of maternity. Now, it's impossible to say whether it was Hearne or actually Eamon de Valera who originally proposed this idea. It was certainly something de Valera felt very strongly about, and some historians have argued that de Valera's views on women and motherhood were influenced by his own personal circumstances. So we know he was sent back to Ireland to be raised by his grandmother while his mother had to work in New York. But there's lots of other influences besides de Valera's personal circumstances. So Hearne himself would have actually been a comparative constitutional scholar. He was very familiar with the European constitutions of the day. And it's clear that lots of our constitutional provisions have been influenced by the German constitution. And Article 41.2 is no different in that regard. And on the slide there, you see examples of similar sentiments, particularly this idea of protection of maternity in a lot of the European constitutions of the time. So sometimes, you know, we do have this feeling that our constitution and Article 41.2 in particular is simply the result of a Catholic Irish influence, but it is interesting to see that these sorts of sentiments were popular in Europe at the time and even in non-Catholic jurisdictions as well. But we can't deny that this article in particular had a major influence in terms of Catholic social teaching. And obviously at the time, Ireland was a deeply conservative society. Its values were Catholic, patriarchal, and women were consigned to the role of mothers in the family home. And going back to the drafters, Hearne himself was a devoted Catholic. He'd actually trained as a priest for 6 years. And we know there were lots of figures from the Catholic Church who were involved in various different stages in the drafting process. And one of those key figures is John Charles Mcquade, the later Archbishop. Now, sometimes his influence on the drafting of the Constitution has been overstated, but his influence on Article 41 is certainly significant. And we know he became personally involved in or around November 1936. He was a friend of de Valera's. He was a family friend. So de Valera was relying on him to provide the Catholic perspective on social matters. Now, we don't know when exactly he started looking at Article 41.2, but we can actually track his influences when we look through the drafts. So if we look at this early draft, first of all, which is from mid-October, and again, it's this idea of maternity. Maternity is under the special protection of the state, and it talks about the idea of birthing hospitals and that the state is going to encourage families and provide support for families. This is very reminiscent of the Weimar provision, which was on the screen a minute ago. So this is before the involvement of Mcquade. This is the direction that the article is going. In subsequent drafts, then we see more development of this protection of maternity idea, whatever that means. And later on in another draft, Hearne actually cuts out this material. There's no mention of women or no mention of mothers. It's all just about the family and protection of the family, prohibition of divorce, and so on. But by February 1937, we see the bones of what eventually became Article 41.2 appearing. And this draft is from February, and it talks about recognizing the guidance of woman in the family and being a support to the state and so on. And then in February, we also see this draft, which is written by Mcquade. It's called the X draft. And as we can see, it's very close to the final provisions of Article 41.2. So it says the state recognizes that by her life within the home, and this is the first time we see that particular wording, woman gives to the state support with which without which the common good cannot be achieved. And the state shall make it an aim to see that women, especially mothers and young girls, shall not be obliged to enter avocations unsuited to their sex and strength. So while the earlier drafts mentioned the idea of protection of maternity along the lines of the European constitutions, the focus here shifts to the importance of the guidance of women. And the Mcquade draft brings in this sentence of a woman's life within the home. And now it's interesting that that very last sentence there about women, certain employment being unsuitable for women, that was later actually put into Article 45. It caused quite a stir at the time. Women's groups were afraid that it might mean that they would be stopped from entering certain areas of employment. So it was put into Article 45, which makes it non-justiciable, but the rest of it was left in Article 41. Now, it's very clear that Mcquade's draft was influenced by a papal encyclical called Rerum Novarum, and that says that a woman is by nature fitted for home work and bringing up children. And we know Mcquade felt really strongly about this idea because women's groups were very critical of this provision when it was published first. And Mcquade writes in his personal papers how upset he is by this, essentially, and he launches quite a strong defense of this. And I'll just read you a little bit of what he says, because the attitude is interesting. So he says, nothing will change the law and fact of nature that a woman's natural sphere is in the home. She's perfectly free to marry or not marry, choose this or that career. No article in the Constitution attempts to deny the woman's fundamental rights as a human being. The article merely acknowledges a fact, the dignity and indispensable role of those women who choose to get married. And having acknowledged that fact, it will endeavour to see not that women will be prevented from engaging in this or that career, but that a certain class of women, namely mothers, will not be forced by pressure of need so as to engage in work to the neglect of their proper home duties. So the provision developed from this original intention to protect maternity to the February draft's paternalistic desire to prevent women being forced into unsuitable employment and depriving the family of their guidance, to finally the now rather insulting insinuation that the proper place of a woman is in the home. And throughout the draft, we can see the focus is on motherhood, childbearing, child rearing, but the decision seems to have been taken at some stage to refer to women generally in the final draft, and that was something that De Valera defended later on in the debates. Now, it's unclear when the exact wording of Article 41.2 was agreed upon, but it appeared in the official first draft in March 1937. And while lots of other provisions were amended and changed later on, 41.2 never changed after that. Now, the wording did not go down well with women's groups. And I know Mary McAuliffe gave a great talk here a couple of weeks ago outlining the protests and the criticisms from the women's groups. And those criticisms actually extended to Article 40.1 on the equality provision, as well as that sentence at the end of Article 41.2, which was later moved to Article 45 on the inadequate strength of women. But when this article came up for discussion in the Dáil, De Valera was shocked by the criticism from the women's groups, and he defended his position and said that he believed that 99% of the women of the country would agree with every line of it. And when he's talking about the provision and defending the provision, he repeatedly refers to mothers. And there's a bit of a strange interaction in the Dáil on this, where deputies start questioning him, do you mean women or mothers? And everybody's a little bit unclear as to whether woman in the first sentence means mothers in the second. But De Valera refused any change to the text, saying he's made up his mind and that's it. On the issue of the intent, and this is interesting because De Valera says he can't understand the opposition to the article because he says the sole aim of the provision is the protection of women. And he says, I would like to know from any woman's organisation what is wrong in saying that we should strive for a social system which would be such as will not compel women to go out and work. Now, some members of the opposition did point out that this was reactionary, it was retrograde, and arguing that he was going to destroy women's rights. But when the Dáil finally heard from a woman on this, and there was only one woman who spoke on this, it was Helena Concannon, a Fianna Fáil TD, and she said that she was glad to hear that the intention was not to interfere with the rights of women. She asked for the President's assurance that no ambiguity in the text could potentially lessen the status of women. But then she went on to praise the provision because she said it recognises the services of women in the home. And she says, women will work better in homes if they've been educated and if they've contact with outside life. Therefore, I hope this article will remain as it stands and that women will avail of it and draw from it its full substance and advantage. Now, the issue of whether the provision was intended to provide some sort of financial assistance also did come up during the debates. But the question was not really answered. De Valera had a typical sort of politician's attitude to it, where he avoided directly answering the question. But he was asked, how are you going to prevent women from being compelled to work? And also there was a proposal to delete the words "her life within the home," which De Valera refused, but then he explained himself. So he says, well, what we're doing here is that if a woman chooses to marry and found a home, that she should not be compelled by modern conditions, which very often force mothers to engage in outside labour, to do that. And it should be the duty of the state to endeavour to see that shall not happen. How the state may endeavour to see that is quite another question. We leave the methods completely and absolutely open, as it is right that we should. So potentially he's talking about some sort of state assistance, but he doesn't want to tie the hands of the executive by specifying this in the Constitution. And he does actually give some examples. So he says, if I was able to organise it, I would try to get for the community as a whole some immediate return from a man who is getting financial assistance. But if it was a woman, I would take the other attitude. By her duties in the home, she's performing for the community as a whole a fundamental service. And I would say that by doing that work, she was rendering an invaluable service to the state. And I would not require of a mother under these circumstances any other form of return, such as I would be inclined to demand in the case of a man. The greatest service she can render is to perform her duties in the due manner, and anything that would compel her to neglect these duties would, in my opinion, be a loss to the state as a whole. So this does suggest some form of economic right may have been envisaged, but there was a reluctance to tie the hands of the executive and to have that stated specifically. And so this all remained subject to interpretation. And all of this tells us that the inspiration behind this is quite complex. We do know that, the strongest influence is this idea of Catholic social teaching. As to whether or not this was all supposed to be symbolic, it very obviously was left open. Now, in one sense, certainly it was intended to be an expression of current prevailing attitudes and the ideal scenario based on Catholic social teaching. But some of those comments about potentially making future provision, while they are vague, they do signal the possibility of financial support in the future. And as we know, this wasn't moved to Article 45, like the final sentence in the draft, which obviously left open the possibility of litigation in relation to this issue. So there's nothing to say that this article could not have been developed into a rights-based provision, as was done to so many other provisions of the Constitution in the 60s and 70s. And we know there are many provisions of the Constitution which were probably never intended to function as they do now, and it's highly unlikely the drafters would have foreseen things like the development of the unenumerated rights provisions. But while we see these radical readings being given to certain parts of the Constitution, for some reason, Article 41.2 did not feature in this trend. And I'm not sure why. I don't know why nobody ever brought a case like this in the 60s or 70s. Because we do know that the lives of women did gradually improve as a result of the feminist movements around this time, but this provision was not part of that change. And this is something Brian Walsh also expressed surprise about when he was writing in 1987. He refers to this article as a protective guarantee. He's surprised nobody has brought it up yet in litigation. And he seems to anticipate that cases would be brought and that the courts would interpret the extent of the protection given by the article. But as it turned out, there's only been a handful of cases which have ever even touched on this provision, and it was never actually tested as to its potential as a protective guarantee for women. Now, I'll just do a really brief run through on a couple of case law examples. It's worth mentioning De Burca versus the Attorney General, because even though this was a really significant case in terms of women's rights and allowed women to be registered on juries, the judgment of the Chief Justice O'Higgins, he actually interprets women's exclusion from juries as conferring a benefit on women, and also felt that this inclusion was in line with and almost mandatory under Article 41, because he said otherwise women would be forced to serve on duties and that, or on juries rather, and that would take them away from their duties in the home. In two cases then, Dennehy and Louth, the provision was used to justify discrimination against men. And in TOG, a similar argument was attempted, arguing that it was possible to discriminate against widowers in relation to eligibility to adopt, but this was actually rejected by the High Court. So it wasn't until actually 1989 that a case came up which gave a central focus to the article. Now, unfortunately, it wasn't on that direct issue of a woman being forced to work when she would have preferred to stay in the home. But it's the only case we have that really gives a deep consideration to this particular issue. And it could have been a legal landmark for women. It could have really given this article some meaning, but that's not how it worked out. So the case is L versus L. And the former Supreme Court judge and president of this organization, Mrs. Justice Catherine McGuinness, represented the plaintiff. And she spoke to me about this case, and she told me that at the time in the late 80s, there had been some discussion amongst lawyers as to what this provision might actually mean and whether or not they might be able to make any use of it in law. So when she came across this client, who she described as very brave, they decided that they would try and make an argument on the basis of Article 41.2. And they were very lucky in the High Court in that they got a judge, Mr. Justice Barr, who was very receptive to these arguments and really understood the contradiction that was involved. Now, the case itself was a marital separation case, and the issue was on the distribution of the property. The house was in the name of the husband only, and under the rules of resulting trusts at the time, if the wife had contributed in money or money's worth, then she could obtain a beneficial interest in the family home. But Mrs. L here was a housewife. She had made no financial contribution. However, Catherine McGuinness argued that since 41.2 appeared to prioritise the role of the housewife and attributed to it such importance that the state was given a duty to protect it, that those who chose this role should not be put at a disadvantage in law. And Mr. Justice Barr recognised the ridiculousness of this situation, while the Constitution prized this role of the housewife, that women who either chose or were forced to engage in labour were actually at an advantage because they could potentially make a financial contribution to their family home and gain a beneficial interest in it. So by becoming a housewife, despite the grand language in the Constitution, a woman was in a much weaker position in law. And in what I think is actually a really well-reasoned judgment, Mr. Justice Barr points out that the Constitution envisages, ideally, that a woman should devote her time and attention to her duties in the home. And also that women who make this choice are then making a sacrifice. And so in return for that sacrifice, she should receive some economic security. Afterwards, Mr. Justice Barr's judgment was actually quoted with approval by another judge, Mr. Justice Barrington, even though it was obiter in another case. But by the time it went to the Supreme Court, things had turned around. And again, Catherine McGuinness told me that they were really doubtful of success in the Supreme Court in any case. They kind of knew the way it was going to go. But as it happened, the Supreme Court really were pretty shocked by the judgment of Mr. Justice Barr. They obviously felt it was pretty revolutionary, and certain members of the court were sympathetic to the arguments of the plaintiff, but while Barr's judgment had concentrated on the constitutional principles involved, and he did take a very purposive approach, trying to give some meaning to this otherwise useless provision, the Supreme Court took a different approach, and they concentrated on the traditional development of property law. They took a very strict separation of powers perspective, and they felt that the High Court had gone beyond developing an existing law and had ventured into the realm of lawmaking. And really, because of that Supreme Court judgment, the provision was rendered meaningless. So nobody ever took a case on that issue afterwards because of that particular interpretation. Now, there were one or two cases in later years which touched on Article 41.2 as a sort of a side issue. And there was attempts made by the judges to give some sort of meaning to the provision. So in the Sinnott case, Denham points out that the article doesn't assign women to a domestic role. She said the point is to recognise the role played by wives and mothers, and that the work is recognised because it has immense benefit to society. But her colleagues on the Supreme Court didn't agree with her that damages could arise as a result of that. And then another interesting use of the provision was made in the T versus T case, which was another separation and divorce case. And Murray went a little further again, and it gave a judgment which is actually somewhat similar to Barr's High Court judgment in L&L. And he says that a woman shouldn't be discriminated against just because the husband has been the breadwinner. And he says that the courts should attribute the same value to the contribution of a spouse who works primarily in the home as a spouse who works outside of the home. And he says that is underscored by Article 41.2. And he tries to give it what he says is a contemporary reading, arguing that when it says woman, it really means parent. Now, the result gave a value to care work in the home, and that's certainly to be welcomed. And Murray's attempt is commendable in terms of trying to bring the provision up to date. But really, there is such an obvious gendered aspect to this provision. I don't think it's right to read it as parent when there is that gendered aspect there, and particularly because of the history of the provision. So really, the only cases where Article 41.2 has had any effect have been either in defeating equality claims or in cases of marital separation. And they're areas where you could never have originally expected the provision to impact. And it's so unfortunate that a case never arose on that direct issue of a woman saying, I am being forced by economic circumstances to go and work. And it's so tempting to hypothesize about the likely conclusion of such a case if it had arisen in front of the likes of, Kenny, Walsh, O'Dowlig, or so on. And a feminist judgment of the L versus L or similar would be fascinating as well. But despite the attempts by Denham and Murray to breathe some life into this, it's clear to us now at this stage that the provision has no use in law. And the consensus seems to be we should get rid of it. But the problem is there is or has been very little consensus to date as to whether it should be replaced. And if it should, what we should replace it with. Now, over a number of years, this issue has been considered by various different groups, and they've given slightly different conclusions. In 1979, this actually wasn't considered. This was the first major review of the Constitution. It was an all-male group. They didn't consider this provision at all. In 1993, the Second Commission on the Status of Women said, delete it. In 1996, they said, don't delete it, but retain it in gender neutral form. And a year later, the All-Party Oireachtas Committee came to the same conclusion, recommended a slightly different wording as a replacement. Similarly, in 2006, the 10th Progress Report on the Family made similar recommendations, and they also recommended an investigation into the establishment of some sort of practical support for the family, and recommended a cost-benefit analysis be carried out on the issue of care work in the home, but this was never done. Fast forward to 2013, the Convention on the Constitution also considered this, and in general, delegates were in favour of retaining the provision, making it gender neutral, acknowledging the role of carers in the home, and there was some idea of providing a reasonable level of state support for carers. And after the Constitutional Convention, this was sent to a Department of Justice task force. And it was their job to try and come up with a way to implement the recommendations of the convention. And they produced a report which considered potential amendment possibilities and arguments for or against. And they focused on 3 potential options. The first one would delete the existing provision and replace it with the wording on the slide. And the idea there is that it would recognise the importance of care work in the home, provide a legal basis for economic support, but preserving executive and legislative autonomy over these matters. It would exclude carers outside of the home because it was felt if it's in Article 41, it has to be limited to the family. And it wouldn't commit the state to any particular level of support. The second idea was to actually put it into Article 45, where they're saying you have the benefit of recognising the value of care work, but knowing that it's non-justiciable. It's simply there as a sort of a symbolic idea. And the third option is delete it in its entirety. But the department task force decides not to recommend that course of action because they felt there was support for the desirability of recognising care work in some form in the Constitution. And none of these various reports recognised any strong form rights-based amendment. And so the outcome of all of this then was the referendum proposal in 2018, where Minister Charlie Flanagan proposed to delete the provision. But there was criticism from groups representing care workers and from the National Women's Council in particular, who argued that there hadn't been a proper conversation on whether we should delete it or replace it. And so the matter was sent to pre-legislative scrutiny, but the Joint Oireachtas Committee couldn't make up their minds either on whether to delete or replace it. So then it was sent to another Citizens' Assembly on gender equality, and they'd considered this along with a couple of other issues. Now, they were due to consider this last year, but due to the pandemic, they only just recently considered this. And what I found very interesting in their meeting, which happened a couple of weeks ago, is that they pushed very hard to give themselves an option to vote on, which would be more than a symbolic replacement, but would be one which would be actually rights bearing. Now, what they were doing a few weeks ago was they were designing their ballot paper. So they're actually going to vote on this issue in April. But effectively, they had to decide what wording they were going to give themselves to put on the ballot paper. And first of all, they decided on 2 questions. So the first question is, should we delete the article or should we delete and replace it? And if they decide delete and replace, they gave themselves 2 options. So do we replace it with something which is more symbolic, along the lines of what was recommended by the Department of Justice Task Force, recognising the value of care work? Their second option actually contains a concrete duty on the state to provide for carers. Now, we don't know what the outcome of their vote in April is going to be. Based on what I saw the day of the Assembly itself, I strongly suspect that they are going to vote for that latter option. And that would be really interesting because this is the only group in all of those reform considerations who've actually looked at this as a viable option. Now, it was partly looked at in the Constitutional Convention, but they had so many potential wordings before them that their results are difficult to interpret. But it does mean that if the Citizens' Assembly vote for a strong form replacement, this will be something new. It will be a new recommendation. But obviously the danger with this is that the government might not accept something that ties their hands or something that they see as having massive economic consequences. But what the wording that the Citizens' Assembly is going to vote on, what that wording is trying to do, and I'm not sure if I'm allowed to share the exact wording with you because I don't think they've published their exact wording yet, but it basically tries to walk a line where it leaves the issue still in the hands of the state. So there is an obligation to provide for reasonable measures, but the language leaves it open for someone to question whether what is being provided is actually reasonable. And that actually makes things interesting because in a way that would bring back the element that was at the heart of the original provision, the idea that as a society we value care work in the home to such an extent that the state should financially provide for it. And obviously it would, would be nice if this article would finally be of some benefit to women and to carers. In terms of my own outlook on this, up until that meeting of the Citizens' Assembly in February, my own preference was for delete simpliciter. And I really don't see the value in a symbolic amendment. I know the National Women's Council and various other people have argued that it's a good thing to have it in the Constitution, even if it doesn't have a practical effect. But personally, I don't see the point in what would be essentially a cosmetic referendum. If it's not going to have any practical consequences, then I really don't think it should be in the Constitution. We shouldn't be cluttering up the Constitution with phrases which are meaningless. However, if the Assembly actually does vote for this stronger form amendment, and if the government was to accept that, and that is a lot of ifs, but that is something I'd certainly be interested in supporting, because it not only brings the Constitution up to date in terms of removing all that paternalistic language, but it would also actually create a duty on the state to provide support for carers. But I think without getting into those separation of powers issues. So potentially, it could realise that potential that was always there, but never actually activated, to show proof of this so-called recognition of women and carers. Now, I'm not sure if that's a realistic possibility, but certainly I think anything that's going to protect and provide for women and carers would be a good thing, and a long time coming as well. So it's great that this week, with International Women's Day on Monday, that we have an opportunity to discuss this now, and I'd be really interested in hearing all of your views on it as well.
Okay, so I want to go, wow, what a tour de force of brilliant detail, and such a wide spread of knowledge, Laura. It's absolutely fabulous. It's what strikes me as I was listening to you was how many people will actually get to hear the background in the way that you've explained it, and it makes one think what a poor debate it may ultimately be. But we can only hope for the best, and we can do our bit to inform ourselves and educate ourselves about it. But that was just terrific. It was just so interesting. I'm going to look and see. So basically we have approximately, I'm not sure what time it is. Yeah, we have about 35 minutes potentially if for questions and comments, and you can do that in two ways. If you raise your hand in the sort of the on your screen, you can Maeve Delargy, who's doing technical support and is chair of the Irish Women Lawyers Association. We'll come to you, and I'll also I'll also read to Laura any questions that are put up in the chat. So I'm just reading. Thank you so much for such an incisive and informative presentation. And then Rosemary, that was Nancy O'Donnell, Rosemary Hagan, wonderful engaging session. I'd like to ask if there has been or could be a query regarding the provision discriminating between married and unmarried mothers or parents, and the financial supports provided in terms of the lone parents allowance. Is that?
Yeah, that's really interesting, Rosemary, and that's something that I definitely came across a reference to it at some stage, and I think obviously if you're going back to the 1930s, I think when they were drafting this, they were assuming that mothers would be married mothers, but obviously it's not fair to make that assumption, and I can't give you a really good answer on this now because I can't remember where I came across it, but I do remember seeing something to the effect that you'd have to interpret this as being all mothers. So notwithstanding the importance of the marital provision in Article 41, I wish I could think of where
I actually wish I could think of it myself, because I know I came across it myself in relation to an argument against their bringing in the lone parents allowance, that it would that in itself would discriminate against married women, or act as some sort of deterrent, to be married, that you could financially benefit.
Is it the Vic Vahuna case maybe you're thinking of?
Exactly. That's who I'm thinking of. Yeah.
Possibly, yeah. But yeah, so I think because of that case, you couldn't really interpret it in that way. But it is really interesting because, I mean, again, in the 1930s, you could easily have taken that interpretation that, given the special protection of marriage in Article 41, that actually that's what this meant, that it had to be married mothers. But yeah, I think the courts have explicitly disagreed with that.